Welcome to Rapid Fire Wednesday, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, partner in our San Diego office, and I'm here today, as always, with Miki Matrician, who's the co-managing partner of WR Immigration's Boston office. How are you today, Miki?
Hi, Kim. Doing well.
Happy New Year. We are excited to be back at Rapid Fire Wednesday with specific immigration updates. Specifically this week, we're going to talk about changes that happened in December of 2024 that are going to impact us in 2025. And specifically today, we are going to be reviewing some of the major announcements that hit us right before the holidays. And one of those that was most significant is an update from the U.S. Department of State, specifically with the J1 exchange visitor skills list. And it's a really big change. So the J1 exchange visitor classification was created to promote the exchange of language, arts, culture, and knowledge between the U.S. and other countries. J1 participants whose skills and home countries are on the list to return to their country after 2 years of gaining experience in the United States will then have to leave the U.S. after the time of their J1 visit. Could be 2 years or less or a little bit longer, but they are required to leave the U.S. in order to bring back what they learned to their home country. And so that was the thought behind this exchange visitor program and the skills list to enable individuals from other countries to come to the U.S., gather that knowledge, and then return to their home country to share that with their colleagues in their home country. So the last time the Department of State had updated their skills list was in 2009. So that was a really long time ago. And they finally did an update at the end of 2024. So Miki, can you tell us, what was that update that State Department did for the J1 skills list?
Yeah. So as of December 9th, 2024, 37 countries were taken off the skills list, including countries like Brazil, China, India, and South Korea. And, for people from countries that were removed from the list, it's a huge benefit because it eliminates the whole residency requirement that you were just talking about. And so this new list replaces the 2009 version. And the great thing about this is that it's retroactive, meaning that, people are no longer subject, even if they were in the J1 program during the time that they were subject to the foreign residency requirement. And so for those people who are no longer subject, they're no longer restricted from pursuing certain U.S. visas like the H-1B or the L-1 or a green card case. And so immediately that restriction goes away. And so now, people can pursue those visas or green card cases immediately, basically. These changes make the J1 visa a lot more attractive if people know that they're not going to be subject to this requirement. And the good news, too, is for the employers. From the employer perspective, that update makes it easier for them to keep their talent that otherwise would have been restricted and would have first had to go home or file a waiver. The only thing is that this does not change the 2-year foreign residency requirement for foreign national physicians based on medical residency and graduate medical education requirements.
Well, that's definitely wonderful news for the J1 exchange visitor program for both foreign nationals and for employers. It's going to open up a world of opportunities, I think. So it's exciting. Thanks for sharing that with us, Miki. One of the other changes that we saw was to the Form I-45 application to adjust status to U.S. permanent resident. And for many years, applicants were required to submit the medical examination results together with their Form I-45 when they first submitted it to the Immigration Service. And then a few years ago, the government removed that requirement and said that individuals could submit the medical examination results at any time while the 45 was pending, typically in response to a request for evidence or at the time of an interview with the USCIS officer if they were scheduled for an interview. And now USCIS has flipped on that policy again, and they announced, which was effective immediately, which caught a lot of people off guard because it was an announcement that said effective immediately, the medical examination results must be included with the filing of the Form 45 application to adjust status. So that is a huge change, especially since all of us have gotten used to that pretty much a lax requirement over the last few years of strategizing with companies and individuals about when to file their medical examination results. So that was our second change we wanted to discuss with everyone. There's yet another one. And Miki, can you provide us with yet another new update from USCIS?
Yeah. So it relates to employment authorization documents that are expiring and the renewal has been filed. The new rule is essentially that where EAD cards for renewals that were timely filed, there was an automatic extension of 180 days. And for a period of time earlier this year, that 180-day automatic extension was extended to 540 days. And then a little bit later, several months later, they changed it back to 180 days. This new regulation essentially makes that 540-day automatic extension permanent, which is a great benefit because if there is a backlog in USCIS and processing the renewal applications, with the 180-day automatic extension, sometimes it wasn't long enough for the government to process before the 180-day timeline was up. And so this additional 540 days definitely brings a little bit more certainty and security to people whose renewals are pending with the government for a while. From the perspective of the I-9s, Kimberly, do you have any commentary? That's kind of your wheelhouse in terms of verification and I-9 compliance.
Yeah, it's actually good news from an I-9 perspective, and allows employers to, in essence, continue what they've been doing for the past couple of years of looking at the category for which somebody received that employment authorization document card. And if that category is eligible for the 540-day extension, the employer can document that on the Form I-9, either at the time of initial hire, but also at the time of re-verification. So having 540 days as opposed to 180 days means that an employer is updating the Form I-9 less frequently. It would be nice for individuals to get their EAD cards much faster. There's been a better way that the Immigration Service has been processing the EAD cards, but there's still been significant backlogs. So this is a way to hopefully during the administration that's coming up in in a week or so, to allow employers and employees a little bit of peace of mind that they have their work authorization for an extended period of time, essentially because we're probably going to experience more backlogs, especially with EAD cards. But from an I-9 perspective, right, it allows the employer to update the Form I-9 less frequently, hopefully. And that's also something that employers should definitely check the M274 handbook for employers online. You can print it out or save it as a PDF. I don't recommend doing that, though. I recommend just going, bookmarking that site, that specific site for the M274 handbook and I-9 Central, because the Immigration Service does provide updates periodically. And if you're just maintaining a PDF, you're not going to get those updates periodically. So that was definitely a good addition with the regulations that came out.
That's a great tip. And I just want to highlight too, though, that the 540 automatic extension, you kind of alluded to it, but it doesn't apply to all EAD categories. So for example, for F1 OPT, the STEM extension having been filed does not make it eligible for the 540-day. It's still at the 180-day extension period. So just a note for global mobility professionals to be on the lookout for the category, as you said.
Right. That's a great point, Miki. And the other one that I think a lot of our global mobility and immigration professionals see, especially we see a lot of it here in California, is DACA, Deferred Action for Childhood Arrivals. So unfortunately, DACA does not have that automatic extension when the EAD card expires, unless there's a new EAD card, the individual's work authorization will end. So that's another key thing to just keep in mind for DACA recipients, to make sure that they file their extension or renewal as far in advance as possible. And for employers, I always recommend keeping track of those expiration dates and reminding your employees, at least 6 months out, so that you can hopefully prevent any types of gap in work authorization.
Great tips.
So, yeah. Well, hopefully we'll have more going forward. We'll talk about some more changes in immigration. And as we see impacts to immigration moving forward, we're going to be excited and here to share those in 2025. So for now, that's a wrap on this installment of Rapid Fire Wednesday. If you don't already follow WR Immigration on LinkedIn, please do. And you can also follow Miki and me on our personal profiles. And then every week we transcribe Rapid Fire Wednesdays into a newsletter that you can subscribe to. And until next week, good to see you.
Good to see you, Kim.